Hello ladies and gentlemen, this is Attorney Sharp Raleigh and I'm making this video because it's H1B season and a lot of students who are on OPT or even on F1 would like to move to H1B if they are getting a job offer, and oftentimes the companies where they are working on their OPT will want to hire them or ultimately give them an opportunity to move to the H1B. So this is a video of a few tips for the students out there if you're moving to H1B. For one, there are two kinds of students. One which are those who are on the F1 right now. They're still in their courses doing, for example, a master's degree, but they have a bachelor's degree already. And the second types are those who are on OPT and who want to move. And of course, you can be moving from H4 and things like that to H1, but we're dealing here with those who are student visas and moving to H1Bs. A few tips you have to know. If you have an OPT which is valid and past April 1st 2016 in this case, but anytime, and you file for an H1B and the H1B gets picked up in the lottery, you are allowed to work until October 1st when your H1B will kick in. I repeat that. If your OPT passed April 1st, and then you file the H1B, the H1B gets picked up with the lottery, you can continue working until October 1st when your H1B will, hopefully it's approved and then gets kick in on October 1st. Now there are another kind of groups are those who are on OPT, but the OPT expires a little bit before April 1st, but they are still within their 60 days of grace period. For those students, they are allowed to stay in the United States. I repeat that. If they are picked up in the H1B lottery, and it's approved, you are allowed to stay in the United States until October 1st, but they are not allowed to work. So the distinction are two kinds even under the OPT. OPT is your OPT is goes above April 1st, you benefit from the cap gap which allows you to work. But if the OPT is before April 1st and you're within the 60 days of grace period, you will be allowed to stay in the United States without the ability to technically work. So it is very important to understand this distinction. And then of course there are those students who ask me, oh, I'm an F1 right now, but I'm not an OPT. Can I file for an H1B? Of course, many students, as you know, do the CPT, and of course not abusing it, but they're where they're working, they really like their work and they want to give them a job offer. So in this case, the students can move directly from F1 to H1. Nothing prevents you to do that, except if you don't qualify for the requirements of an H1B. And of course, the requirements of an H1B is a bachelor's degree. But bachelor's degree in itself can also be based on experience. For example, each 3 years of experience will be equivalent to 1 year of school, and you need 4 years of school total to be equivalent of a total bachelor in the United States. So if you're an F1, for example, you come here to do a master's degree, you got a job offer and you want to move to H1, well, apply for your H1. If you make it to the lottery, good luck to you, you're going to do well. Now for other students who of course are not going to make it through the lottery, that's where it gets a little bit tricky. And if you are on your OPT last year, and of course hopefully the new OPT STEM will be there, for some people it will be a relief. But what happens if it is not there, or you don't qualify for a STEM extension? What do you do? Well, there are many other options apart from the OPT, and I'm not going to go apart from the H1. So there might be option of you qualify for an O1 visa, a P visa, an R visa, U visa, which is BEJA if you have been victim of some crimes, and also if you are victim, if you have you might also qualify directly for the green card. For example, I had a client who was born in the Middle East but is originally from India, so he doesn't need to go through the H1B process. He can file directly the labor certification and obviously the green card and under EB2 if he qualifies or she qualifies under EB2. But there's a little consequence of that. If in case you file it, then you will not be able to probably renew your F1, because once the I-140 is filed, you are technically ineligible to, you have an immigrant intent and you will be violating INA 214B. But the good news is that if your I-140 is approved, guess what? No problem. You can just file your adjustment of status. If you're under EB2 from a country, born in a country, I repeat that, is born in a country, or your spouse is born. You can also use your spouse country of birth. It's called cross-country chargeability. I mean, not cross-country, I'm sorry. It's called cross-chargeability. I say cross-country because I like the running. But it is cross-chargeability. So you can use that in case you need to use that for your spouse country, spouse's country, in order to qualify for your EB2 and be current on your priority date. So there are other options, EB1A, of course, which I've discussed extensively on the other YouTube videos. Check them, the same YouTube channel, and also national trust waiver, etc. And sometimes you might not know, you might qualify for some other kinds of visas you don't know about. Give us a call, we'll be glad to assist it for you. Number 510-742-5887. This is Attorney Shaprali signing off, and anything I told you today, ladies and gentlemen, is for educational purposes only. You should not act or refrain to act solely on the information provided. You should contact an attorney if you have any questions. The website to check, attorneyonair.com, or immigration legal blog for our blog. Thank you, and please subscribe to our channel and post your comment on the comment side if you have any questions. Thank you.